morning, everybody. My name's Sam Wright, and I am one of the associate solicitors here at Hempsons in the inquest team. I am joined by Eleanor Howson, who's one of our solicitor apprentices, and Zara Ameen, one of our paralegals who work alongside myself in the inquest team. Just a little bit about the team. As a team, we represent and support healthcare organisations with representation at inquest, and we're really pleased to be bringing you this webinar today, focusing on what to expect if you are called to inquest to give evidence. Now, how things will work is Zara and Eleanor will lead the webinar, and there will be an opportunity at the end of the webinar to ask any questions, and we'll seek to address those between the three of us. So without further ado, I'll hand over to Eleanor, and she will take you through our agenda for today.
Thank you so much, Sam, for the introduction. From looking at the attendee list today, I've seen we have a great mix of clinicians, NHS Trust legal teams, and other health and social care organisations. So I think whether or not you work directly in healthcare, the key principles relating to inquest and giving evidence as a witness are broadly the same. So we hope this introductory session will be useful and relevant to everyone in attendance. Over the course of the session, Zara and myself will be covering the following key topics: what is an inquest, understanding the scope of an inquest, reasons why you may be called to give evidence, swearing on oath or making an affirmation, the process of giving evidence in court, who may ask you questions during the hearing, and practical preparation, including guidance on appropriate dress, courtroom behaviour, and how to address a coroner. We'll make time at the end for questions, so as Daniela previously said, please do pop any queries into the chat box, or you can use the hand function to raise your hand as we go, and we'll aim to respond to as many as we can. Our contact details will also be available on the final slide, so should you wish to follow up with us afterwards, either by phone or email, then please do. So let's begin with the fundamental question: what is an inquest? An inquest is essentially a public judicial investigation conducted by a coroner to determine how someone came by their death. It is essentially a fact-finding exercise which is governed by the Coroners and Justice Act 2009 and associated rules and regulations. An inquest is required by law in certain circumstances, specifically where the death is sudden or unexpected, violent or unnatural, occurs in state detention, for example, in police custody, in prison, or in mental health setting under the Mental Health Act, where the cause of death is unknown after a post-mortem. An important point to emphasise, and hopefully this will help to put minds at ease, is that an inquest, unlike criminal or civil proceedings, it is not about assigning blame, guilt, or liability. It is non-adversarial in nature, meaning that there are no opposing parties or side that one would typically see in a courtroom trial. It is a neutral fact-finding process aiming to establish 4 statutory questions. These are who the deceased was, when they died, where they died, and how they came by their death. These 4 questions form the framework of every inquest and will be a recurring reference point throughout this session. In certain cases, where Article 2 of the European Convention on Human Rights Act is engaged, the right to life, which I briefly come on to now, the coroner may also look into the wider circumstances surrounding the death. As this is simply an introduction webinar, I won't go into too much detail on inquests that engage Article 2, but I do think it's important to be aware of them. So Article 2 inquest typically involves situations where the state had a duty to protect life and where that duty has then been breached. For example, deaths in custody or involving police or healthcare settings. In these cases, the inquest may consider not just how the person died, but also the broader circumstances surrounding the death. This can lead to a more detailed investigation than in a standard inquest. Just to add to this, most inquests are presided over by a coroner alone, but there are certain circumstances where a jury may be summoned. These include cases where the death occurred in state custody, The death resulted from an act or omission of a police officer or state agent. The death was caused by an accident, poisoning, or disease requiring investigation for public health reasons, or the coroner may just believe that there is sufficient reason for a jury to be involved. In these cases, the coroner still oversees the hearing and advises on the law, but it is a jury who answers the 4 statutory questions that I mentioned earlier, and it is a jury that will deliver the final conclusion. So now that we have established what an inquest is, and when it may be required, it is helpful to explore what happens once an inquest is opened. So once the coroner has decided that an inquest is necessary, a preliminary investigation will begin. At this early stage, the coroner is building a picture of what happened to determine whether the legal threshold for holding a full inquest has been met and what information will be needed to answer the 4 statutory questions. So let's take a closer look at the role of the coroner in all of this. So coroners are independent judicial office holders, and under the Coroners and Justice Act, all coroners must now be legally qualified, typically as barristers or solicitors with at least 5 years of legal experience. While a medical qualification is not mandatory, some are actually medically qualified legal practitioners, which reflects the dual legal and medical nature of the role. Historically, coroners were appointed without formal qualification requirements, but the introduction of these standards has helped to promote consistency in the conduct of inquests. In practical terms, the coroner's responsibilities will include requesting and reviewing medical records, instructing a post-mortem examination if one hasn't already been completed, and gathering evidence from individuals involved, including clinicians, emergency services, family members, and others who may be able to provide insight into how the death occurred. And at the end of the inquest, the coroner will complete a formal document called the Record of Inquest. This is essentially a document which sets out the answers to the 4 statutory questions. They will also deliver a conclusion based on the evidence heard. This conclusion will either be in short form, so for example, accident or misadventure, natural causes, suicide, drug or alcohol-related death, road traffic collision, unlawful killing, lawful killing, or stillbirth. Where a short-form conclusion is not appropriate, the coroner will outline the descriptive factual findings in a narrative conclusion. This can be anything from 1 or 2 sentences in length to a longer paragraph. Having covered what an inquest is, when it is required, and the key role of the coroner plays, it is now important to turn our attention to the scope of an inquest. Thank you, Zara. In other words, what exactly an inquest can and cannot investigate. Understanding the scope is crucial because it establishes clear boundaries for the investigation. It determines the extent to which the inquiry can explore the circumstances surrounding the death, what evidence may be considered, and which questions the coroner must address as part of their conclusion. When we speak of the scope of an inquest, we refer to the range and limits of the issues the coroner is legally authorised to explore during the proceedings. At its core, the scope is focused on answering the key 4 statutory questions. The scope is governed by Section 5 of the Coroners and Justice Act, which requires the coroner to investigate only what is necessary and proportionate to answering those 4 statutory questions. The coroner has discretion to define the scope, but it must be exercised fairly, rationally, and with regard to the evidence available. This may mean that as new facts or evidence emerge, whether prior to the inquest or during the inquest itself, the scope may broaden or narrow accordingly. It is also important to note that the scope can vary significantly from case to case. For example, when Article 2 is engaged, as I briefly mentioned earlier, the scope of the inquest is typically broader. The scope is primarily determined by 3 key factors. These are, number 1, the facts that surround the death. So the coroner's investigation is limited to facts directly related to the death itself. This includes circumstances leading up to and immediately surrounding their death, but the inquiry will typically not stray into unrelated matters. Legal boundaries set by statute and case law, so the Coroners and Justice Act 2009, along with relevant case law and procedure rules, set out the legal framework that governs how far the coroner may go. And if the coroner exceeds these, then and doesn't act rationally or proportionally, then their decisions may come under judicial review. And as previously mentioned, when Article 2 is engaged, there are human rights considerations and the scope may be extended. And in such cases, the coroner may have a duty to explore the wider circumstances, including systemic failures or state responsibility. I think it's equally important to understand what an inquest cannot do. So, to put minds at ease, it is not a forum for assigning civil or criminal liability. So while a death under investigation may also be the subject of separate criminal or civil proceedings, the coroner's role is entirely distinct from those processes. The inquest is concerned with facts and not faults. And where parallel proceedings are ongoing, the coroner may choose to adjourn or narrow the scope of the inquest to avoid prejudicing those cases and to ensure procedural fairness. It is not a venue for resolving disputes between parties. So, as I previously mentioned, unlike a courtroom trial, an inquest is not adversarial. There are no opposing parties arguing for or against liability. Its sole purpose is to establish the facts surrounding the death. And it is not an opportunity for adversarial cross-examinations. While witnesses can be questioned by the coroner or legal representatives of interested persons, the questioning is aimed at clarifying facts rather than challenging credibility or assigning blame. And it is also not a forum for awarding compensation or damages. The inquest does not deal with civil claims. Any issues relating to compensation must be pursued through separate legal proceedings. Why scope matters for witnesses and professionals. So for anyone involved in an inquest, whether as a witness, an expert, or a legal representative, understanding the scope of the inquest helps to focus preparation. So we often conduct and hold pre-meets with trust witnesses so we can establish the evidence and issues that will be directly relevant to the coroner's investigation, and it avoids time spent on matters outside the inquest remit. It allows witnesses to prepare for the questions likely to explore during the hearing. And we also explore what the coroner can and cannot consider, which helps manage expectations and will obviously reduce any unnecessary stress. Ultimately, it is the coroner who determines the scope of the inquest, carefully balancing several key considerations: the need to conduct a thorough and meaningful investigation, avoiding unnecessary overlap with other proceedings, and respecting the rights and interests of the family and other interested persons, and essentially serving the public interest by ensuring transparency and accountability in the process. And the next slide, please, Zara. Thank you. So to understand why you might be called to give evidence, it's helpful to first consider the broader legal framework around who is involved in an inquest. So under the Coroners and Justice Act, the term interested person is used to describe individuals or organisations who have the legal right to participate in the inquest process. They are essentially entitled to see the evidence and the case bundle, attend hearings, and be kept informed throughout the process. So most obviously, this will include the family of the deceased, who are always considered interested persons, but interested person status can also be extended to NHS trusts or organisations. This status essentially gives certain legal rights. So firstly, it would give access to disclosure. You will be entitled to receive the evidence that the coroner relies on, usually in the form of a case bundle. It'll also give you the right to ask questions. Through a solicitor or barrister, you can question witnesses during the inquest hearing to clarify any facts or explore any further relevant issues. The ability to make legal submissions. So typically through a solicitor or barrister, You may contribute to submissions on key legal points, such as appropriate scope of the inquest or whether Article 2 is engaged. And challenging coronial decisions. In limited circumstances, you may have the right to seek a judicial review of the coroner's decisions. In terms of the work we do, we represent hospital trusts and other organisations when they are made interested persons. A common challenge arises when bereaved families or other interested persons wish the coroner to examine broader concerns, such as potential systemic failings, staffing issues, or wider organisational practices. While the coroner does have discretion to explore these matters, if they are directly relevant to the cause or circumstances surrounding their death, they must still act within the legal boundaries of the inquest remit. So the coroner has discretion to broaden or narrow the scope as appropriate based on the evolving evidence and legal framework. However, this discretion is not unlimited and decisions on scope may be challenged, as I previously mentioned, by way of judicial review. This is when they are considered irrational, unfair, or unlawful. The next slide, please, Zara. So now we're going to turn to why you might be called to give evidence at inquest. So let's look at one of the most common questions we're asked. Why might I, as a clinician or a healthcare professional, be asked to attend an inquest? So separate from interested persons, many individuals are called to inquest simply in the capacity of a witness. That means that you are called to provide information based on your involvement in the patient's care. The range of professionals called as witnesses of fact is broad and can include consultants, registrars, junior doctors, nurses and healthcare assistants, mental health professionals, support workers, case managers, GPs and community practitioners, ambulance personnel, and police officers or emergency responders. The list goes on. Your involvement may include describing the care you provided. For example, you may have been directly involved in the patient's treatment near to their time of death or during, say, a period of deterioration, a change in treatment, or a hospital discharge. You will often be asked to detail your observations, such as changes in the patient's condition, their behaviour, or any incidents that occurred. And often you'll be asked to clarify the timeline of events, particularly where multiple clinicians or departments were involved. It is also important to be aware that even if you were not directly involved in the deceased's care, you may still be asked to give evidence. This could be because you authored or contributed to a serious incident investigation or internal review, or perhaps you hold a senior or management position and can provide context about systems, protocols, staffing, training, or governance arrangements within the organisation. Your role as a witness may be very focused, such as describing an emergency response, or much broader, such as providing a full overview of the patient's journey through a service or department. In some cases, where two or more individuals have overlapping evidence, the coroner may decide that only one person needs to be called, or that a written statement alone is sufficient. However, as a general rule, I would say that if you have provided a statement for the purpose of an inquest, you should expect and be prepared to be called to attend in person unless formally told otherwise. I'd just like to reiterate the point that if you're ever uncertain about why you've been asked to give evidence or what your evidence will be used for, it's important to speak with your Trust Legal Services team, or you can contact our inquest team for support. We're here to guide you through the process and help you understand your role and ensure you feel confident and well prepared. Most people become involved in an inquest after receiving a request to provide a witness statement from either your organisation's legal services department or directly from the Coroners Court. Your statement should set out your role, your professional background and qualifications, and including any changes since the time of the incident, the care, treatment or interaction you had with the deceased, any observations or actions you took at the time, and relevant records of documentation you authored or relied upon. Depending on your involvement, your statement may also provide a summary of care over a period of time, a focused explanation of a specific event, decision, or clinical concern, a broader overview of departmental processes, staffing levels, training, or relevant policies. A well-drafted statement is a foundation of any contribution to an inquest, and the clearer, more factual and comprehensive your account, the more helpful it is, and in some cases, the coroner may decide that your written statement alone is sufficient without the need for oral evidence. So this is called under Rule 23 of the Coroner's Inquest Rules. The coroner has discretion to read a witness's statement aloud in court rather than calling the individual to give live evidence. This is only permitted where the statement covers uncontroversial or purely factual content and no interested person objects to the statement being read in court. So the more comprehensive and clear your statement is, the more likely it is the coroner may consider using Rule 23 to avoid calling you, especially if your involvement was limited or there is overlap with other witnesses. The next slide, please, Zara. Thank you. So if you receive a formal summons from the coroner, you are legally required to attend court, and failure to do so without reasonable excuse could result in a fine of the organisation up to £1,000 for contempt of court. Even without a summons, if the coroner requests your attendance, you are strongly advised to treat it as mandatory. A summons can be issued if you do not attend without agreement, but however, if you do have a genuine reason why you cannot attend, for example, this may be because of illness or travel, please do inform your legal team or the coroner's office as early as possible, as in these certain circumstances, attendance may be excused or rescheduled. As I previously stated, if you're unsure why you have been contacted, or if you ever feel anxious about the process, please don't hesitate to speak with your legal services team or do get in touch with us. There is support available at every stage. I'm now going to hand back over to Zara, who will take us through the next part of the session. She'll be covering the topics swearing on oath or affirmation, what to expect when given evidence, who may ask you questions during the inquest. Zara will explain how the process works on the day and offer some practical tips to help you feel more prepared and confident when attending court.
Thank you, Eleanor, and thanks for Sam for introducing me. So that's the legal framework of an inquest, and I'll explain how the legal framework translates to the reality. So this is Sunderland Coroners Court, and obviously this depends on each courtroom because it differs slightly, but largely who sits where remains the same. So when you walk into the Coroners Court, it looks quite formal, but knowing who sits, again, where can make you feel more at ease. So the coroner, who would be seated at the front, usually is seated on a slightly raised bench, and that's deliberate because it emphasises their role as a decision maker. The coroner's officer or coroner's clerk, otherwise known, will usually sit close by, typically in front of them, or as you can see here, is at the side, and they help manage the process, they swear the witnesses in, and they can guide you if needed. They also help in recording the inquest, which is via audio, not via video, so please don't worry. And the witness box or table is where you'll sit giving evidence. This is lower down, and typically it's faced towards the coroner, but as you can see here, it's towards the side. But you can feel as though you're speaking one-on-one with the coroner, so that could make you feel a bit more at ease as well. The family, and if they're represented by a lawyer, they'll sit opposite or slightly to the side of the coroner, and they'll typically be granted interested person status, which Eleanor helpfully discussed earlier. They'll be able to ask questions, and just a note, if they are unrepresented, some of the questions can fall outside of the scope of the inquest, therefore not answering the full questions. And the coroner at this point, or your representative, will be able to interject and revert back to the scope. The trust lawyer or representative will sit nearby, often behind or to the side, and other interested persons will also have seats available. There's occasions where a jury may be held, which Eleanor again raised earlier, and I'll discuss this really briefly because, as stated, it's quite unusual, because most inquests are heard alone by the coroner, but in certain circumstances like deaths in custody or involving public safety, a jury must be called. The public gallery is at the back or the side, and they can include members of the public, sometimes the press, which again, please don't worry. And if you do have any concerns, please contact your legal team to address those concerns. And it could also contain observers, so student nurses, for example, just to observe an inquest and see how an inquest is conducted. Sometimes the courtroom can feel full and formal, but the layout is there to keep the process structured. So again, this is like another diagram where you can see the courtroom and see who sits where. It's relatively consistent. This is straight out of our inquest handbook, and that's deliberate. We don't expect you to memorize this, and the handbook is there for you to revisit, so please feel free to request this if you do need a copy. The key thing is just knowing where you'll be, so it feels less intimidating on the day. So moving on to swearing an oath and affirmation. So once you're called, you'll be shown where to sit or stand. As you can see, if you are religious, you'll give an oath. And if you are an atheist, or if you're non-religious, or you don't feel like you want to provide an oath, you can provide an affirmation instead. You don't need to memorize all this because it's all prepared. And as seen on the slides, the coroner's officer will prompt you with the words. Both carry the same legal weight. My advice is simple, just choose whatever you feel most comfortable with, because the most important thing is being at ease so you can focus on your evidence. Moving to the next slide. So once you've provided your oath or affirmation, and once you're in the box, the coroner will ask you to confirm your name, your job, sometimes your qualifications, and the duration of how long you've been at that role. As Eleanor said, it would be helpful if this was also contained in your witness statement so you can cross-reference it at any point you feel necessary. Then the questions follow a set order. So the coroner will typically begin, then the family representatives or the close friends. If they are unrepresented, then they'll choose someone like a spokesperson to feel more comfortable asking those questions. And then other interested persons, and then finally your own organisation's representative if they wish to clarify anything. But this tends to be rare because most of the questions are already addressed by the coroner. So my golden rule is this: you're only expected to answer within your role and expertise. If you don't know or can't recall, please do say so. If you need something repeating or you may not understand a question, again, please feel free to ask. Speak slowly and clearly. Everything is recorded. And my top tip is if you're using medical or technical jargon, sometimes it helps to explain that in everyday language so that the family and the coroner can follow along. Remember, you're not expected to know everything, but you are expected to be accurate to the best of your knowledge and belief. And if you think you're not the right person for the line of questioning, then please do say so. I also want to add, if you do feel upset at all providing evidence or even prior or after, please feel free to contact your legal team or your representative and they can discuss your concerns further with you. And I would say it's quite normal to get upset because it's quite a personal process in and of itself. So respect for loved ones. This is entirely discretionary and up to you. But at the heart of every inquest is the family and friends of the deceased. And as professionals, some witnesses may go to inquests often, and so it can feel quite routine. But again, it's deeply personal and can be quite upsetting both to the families, the friends, and of course yourselves as the treating professionals. That's why the way we give evidence matters, not just the way we say it, but how we say it. At the start of evidence, before answering questions, or at the end after answering questions, you can express your condolences. This is perfectly appropriate, as seen on the slides. It doesn't need to be long at all, but a simple acknowledgement is often appreciated. So my top tips on giving evidence: keep your answers clear and understand what you're being asked. Please try not to guess the answer when you're unsure because it can put you in a bit of a pickle. Take your time to answer questions. Again, to reiterate, try to avoid medical jargon and try to explain the technical terms in layperson terms. And if you don't know an answer, or if it's too speculative to say, that is an answer in and of itself, and that's completely valid. And finally, address the coroner as either sir if it's male, or female if it's ma'am. Reminder, you are there to assist the coroner where possible. So, practical prep. The best way to achieve providing good evidence is by prepping beforehand, both professionally and practically. So refresh yourself with the details of your witness statement and review key records prior to the inquest. What I would suggest is looking at the records, see where you referenced, maybe even make a little chart, and understand why you referenced, what the context of that medical note is, or like recorded document, and see if there's any next steps that were taken after that. Double check the dates, times, and details. So if there's an error, you can amend this in a supplementary statement, or you can verbalise this at the inquest itself if you do feel comfortable to do so. Plan travel and arrive early. Dress appropriately, professionally, but also comfortably. This depends on the trust or your care provider. Sometimes it's uniform or it's suit and tie. Again, it's at their discretion, so please feel free to ask your own representative. And finally, please look after yourself. Make sure you get a good night's sleep, make sure you drink enough water, and have some food. And again, if you do feel upset at any point, please do say so, and your legal team, or if you instruct ourselves, then we are here for you. Now, finishing off, that's everything from me. I'll hand back to Sam and Daniela to continue with the session, and I and Eleanor will contribute to the answers where possible. I think the key thing here to take away is to be confident within your evidence, and if there's any errors, again, be confident to say so, and that you're not alone at any stage. Thank you.
Thank you for that, Daniela. Really good question there. Yeah, absolutely. A coroner can compel a witness to attend Coroners Court to give evidence or to write a statement if he feels that witness has some relevant information for him or her that will answer one of the 4 statutory questions. If the coroner does ask for your assistance with that, it's important to comply for the reasons set out helpfully by Eleanor previously. Yes, absolutely. I mean, where possible, it's it's important for anyone involved in the care and treatment to provide their own evidence. But if for whatever reason that clinician isn't available, or the trust feel that someone else is best to provide, say, for instance, an overview witness statement, which we see quite commonly, it is appropriate for another witness to provide evidence on behalf of someone else who has conducted that care and treatment, and we see that quite often. Well, that can be twofold, really. Generally, the coroner will ask you to assist based on your involvement in the care and treatment, but equally, the coroner can also ask you to assist to provide evidence on an opinion based in line with your expertise. So it's quite usual for witnesses to be asked to assist in a case where they, say, for instance, haven't been involved in the care and treatment, or indeed even have met a patient. But if you hold relevant expertise in a particular area, the coroner can ask for your assistance in terms of providing your medical opinion and expertise on a certain matter.
Oh, sorry, Sam.
No, Eleanor, you go on.
Allowed to continue to observe the proceedings, but we would just warn that unless you've been kind of, the coroner will say that you're not under oath anymore or under affirmation, so you can leave the courtroom if required. But there is always a possibility that if other evidence comes to light in, say, another witness's statement that you might have factual knowledge on, and you might be able to respond to a question that that witness who's currently in the witness box may not be able to respond to, that there is always a possibility that you could be called again. So we just tend to warn witnesses of that, but of course you are able to sit and watch the remainder of the proceedings. So at the end of, say if the hearing lasted more than one day, we would provide the trust with an update or at the end of each day, so they understand where the proceedings are heading. And then at the end of the inquest, once it's concluded, we'll also provide a record of the inquest. So the coroner will provide the record of inquest to us, and we will send it directly to your legal services department, and often CC all the witnesses in so they understand the final outcome as well. I would say civil and criminal proceedings are entirely separate to what is investigated in Coroners Court. The coroner does have discretion to make recommendations to the trust or of our organisation. So I don't know if I mentioned it in my slides, but they have a power to issue a prevention of future deaths report, which is essentially a recommendation to the trust that changes need to be made to prevent this occurring in the future and to prevent any future deaths. But this is only a recommendation, and this is up to the trust how they respond to that.
So usually it's the last day of the inquest. So you'll usually know, or the trust legal team would usually know ahead of time in terms of who's presenting the inquest. I mean, who's presenting the PSII, if it's a PSII, if it's a rapid review, or sometimes if it's an AIR. I know that's dependent on each trust of what they're called. So essentially, once the trust finds out the name of who's presenting it, then that name will be provided to the Coroners Court, and then you'll be called formally to provide that evidence.
Yes, absolutely. So it's quite rare, but if a coroner makes an incorrect decision or makes the incorrect legal finding, or it's believed that the coroner has made an incorrect legal finding, then there is scope for an organisation to make an application for judicial review. It's quite rare, it's very expensive, and there has to be a clear case for an application for judicial review to even consider going down that route. So it just depends what the issues are and what the what the findings are deemed to be incorrect. If it's a case of a prevention of future deaths report has been issued against an organisation, that isn't usually a reason to intimate judicial review proceedings, just based on the fact that it's extremely costly. And ultimately, if the coroner feels that changes should be made, or feels that there's actions that need to be taken, it's quite a subjective viewpoint. So the coroner is well within his or her rights to send that report out.
So under Rule 23, the coroner is able to read your witness statement into the inquest hearings rather than call you to give live evidence. So I would say, as a general rule, expect and be prepared to be called to give live evidence if you have been asked to prepare a witness statement. But there are certain circumstances where if your witness statement goes into all the facts that are relevant to your role, they are more likely to consider and using their discretion to read it in rather than calling you to give live evidence.
Yeah, so I think the coroner published some guidance in terms of witness statements. You can circulate a link if you'd like. along with our handbook and this presentation. But it'll go into a bit more detail in terms of like numbered paragraphs, which I know is dependent on the trust if they'd like to use that. The job, title, the name, obviously, of the witness, qualifications, etc.
Thank you. I'll take that one, Daniela. Ultimately, if the coroner makes a finding which is suggestive that a death has been caused or contributed by an act or omission by an organisation, and the conclusion intimates as such, that can be used as persuasive in the civil court, then say, for instance, in a clinical negligence claim. Thank you. Not usually. The coroner would have an idea of what questions certainly the coroner wants to ask his or her witnesses at inquest, because they would have had all of the evidence and considered the evidence beforehand. The coroner wouldn't usually know what questions are going to be asked by the interested persons themselves. However, I expect any experienced coroner will have an idea of the questions that may come up or may be asked. But of course, it's certainly down to the individual interested person to ask any question that's within the scope of the inquest of those witnesses, and they have that right to do so if they have interested person status.
Can I just add to what Sam has just said and say that once the coroner has finished their questions, they will then open questioning to the interested parties. So whether that be the members of the family, they will then go on to ask the witness their questions if they have any, and then to the legal representatives of the other parties, and open it up for questions from them.
I would just add that the coroner would interject if he feels that the line of questioning is inappropriate, just to remind them of what's in scope and what his or her investigation is about. So those 4 questions that Eleanor discussed earlier.
In certain circumstances, it may be that the family doesn't have legal representation, so they often do ask questions that go beyond the scope of the inquest, but the coroner, as Zara mentioned, does have discretion whether to allow such questioning or not allow it.
Okay.
I think I'll need to research that information and come back to you.
Yeah, I think from speaking to someone about it a couple of years back, I think it's 1 to even possibly 3 cases a day. So the coroners are busy practically all the time. But Sam can go into it further if she feels like she needs to.
I mean, absolutely, it's anyone's guess, isn't it? But I mean, ultimately, there's a number of coroners' courts in and around, certainly even the northwest, that you usually have a coroners' court per area. And they all have a number of coroners sitting at those coroners' courts, whether that's assistant coroners or senior coroners or area coroners. And so depending on how many coroners you actually have at one coroner's court will determine the capacity they have to hear how many inquests they hear on any particular day. But if you're really interested in the numbers, you know, you can always log on you can always see the listings on the internet on various coroners court websites on a daily and weekly basis if you're really interested to see how many inquests they're actually dealing with on a daily basis. But I think that's as far as I can go in relation to that without actually going on to the individual websites and counting up the numbers. I'm assuming that question is in relation to any potential civil claim that might arise on the back of a conclusion of an inquest. Again, it varies and it just depends on the facts of an individual inquest. I mean, when we talk about inquests, and certainly the work that we deal with at Hempsons, you know, we're dealing with the most complex of inquests usually, but what we mustn't forget is that inquests are very, very common, and it's, if we don't forget that, an inquest will take place where someone's considered to have died an unnatural death. Now, a lot of deaths can fall into that category, and by and large, the majority of inquests that coroners courts do deal with are inquests with no issues, and inquests where clinicians are asked to provide a statement, and a statement's provided. Sometimes they're asked to attend to provide oral evidence. Sometimes that statement is accepted and read out in court, and a clinician isn't asked to attend. So there's a variable amount of inquest, from simple inquest to a more complex inquest, and it just really depends.
I think I referred the lady to the Benchbook Guidance chapter 15, because I think I was reading up on this yesterday myself. But Sam is helpfully nodding along, so she can go into it further.
Yeah, in terms of the more than minimally, what we have to think about is when a coroner's making a decision in terms of any causative impact of a particular death, and making the standard of proof is the balance of probabilities. So the starting point for a coroner is whether on the balance of probabilities a death occurred in the way that the evidence suggests it did. The balance of probabilities is more than 50%, so more likely than not. And then as a addition to that, the coroner then considers whether, if it is on the balance of probabilities, more likely, is it more likely more than minimally? So you still have to get over the balance of probabilities. You still have to consider whether something is more likely than not. And then when you get to, yes, it is more likely than not, then it's, well, did it contribute more than minimally trivially? So is it more likely than not? And if yes, is it contributory just even by just a little bit? And that's sometimes the confusion with inquests, and not a matter for witnesses to be too bogged down with, really. It's a legal test, and something that your legal representatives, and of course the coroner, it needs to consider, but not something that a witness needs to get too bogged down with. But certainly it's helpful to have an awareness of that. But I'm not sure if that helps with the question. Hopefully it does.
Of course. I would probably direct you to asking your a legal representative at your trust or organisation whether they have any upcoming inquests that you may attend, just to get prior experience in the event that you are called or asked to provide a witness statement. So that'd be my first point of call to direct you to.
Yes, absolutely. And if it's if your legal team are unable to assist, because it might be that they don't have one that's helpful to you, that they think's appropriate for you to attend, for whatever reason, there's no reason why you can't call the coroner's office and say, I'd like to get some experience. I'm attending an inquest. I'm looking for an inquest to observe. Can you recommend any that are coming up? And it's helpful for you to contact the one more local to you, so you're not having to travel. But it's a public hearing. Anyone can go and observe and sit in the back of an inquest, but it's just courtesy to let the coroner's court know that you're going along. That's a good question. It's always you've always got to balance whether it's appropriate or not, or whether to do so you're going to make things even more difficult or not. Ultimately, the coroner has a wide discretion to ask whatever questions the coroner may feel necessary. It might feel sometimes that the process can become a little bit adversarial for whatever reason it shouldn't do, your legal representative can, if they feel appropriate to do so, politely interject if necessary. And I have seen that happen. I have done that myself. But sometimes it's a judgment call depending on what the issues are, what the questions are that are being asked, and how far the coroner is going, and how they're presenting themselves, really. But I mean, what's really important to mention really is that, you know, by and large, on more often than not, most coroners are arraigned, certainly the coroners the inquest that I've sat in, the coroners that I've been in front of, are courteous, and they are respectful, and they do you know, take their time with witnesses. Some can get frustrated for whatever reason, but it really depends on the circumstances and what the issues are as to whether it's appropriate for a legal representative to step in. But it's certainly something that can happen.
Thanks, Sam. So we've reached the end of our time today for this session. We have received a couple more questions, but I've included the speakers' details on the screen. So if you do have any further questions or follow-ups, then please feel free to email them or email us at events@hempsons.co.uk. And thank you very much, everyone, for attending today.